Court's in session, please be seated.
Larry?
In the intervening time, at the court's request, the Commonwealth was able and has provided copies to counsel as well to obtain certain reports that the court was interested in reviewing. The Commonwealth was able to receive the report from the Bristol County Correctional Facility of the assault on January 26, 2009 of Correctional Officer Cabral. In reviewing that report, Your Honor, the Commonwealth noted that there was not detailed information about the injuries sustained other than visible head injuries at the time of the assault. The Commonwealth did ask a detective who was present to reach out to that correctional officer who was the victim. He did that, and we did confirm today, and I indicated that on the report, that the injuries resulting from the assault was a concussion, a laceration to the head, a chipped front tooth, and the correctional officer was out of work for 6 weeks due to concussion as a result of that assault. That assault occurred in 2009. That assault also occurred, Your Honor, while the defendant was at the Bristol County Correctional Facility, held awaiting trial here in this court on a murder charge at the time. Awaiting trial. The full reports were off-site stories that were not available at this time. But the information is clear as to date and a basic synopsis of facts of the incidents. The Commonwealth notes, one of particular note is the having and hiding of a sharp object behind a radiator in the area of Mr. Russ's cell on the Bristol County Correctional Facility. The Commonwealth was also able to obtain from the state prison system where the defendant served a 2.5 to 3 year sentence for the assault on the correctional officer of any disciplinary incidents that the defendant, Mr. Russ, had when he was there. In the summary portion of that, it appears as though he had received 3 D reports while there. The assault on staff occurred and the Bristol is referred. It also refers to the height of the sharp implement. The defendant was sentenced and committed first to NCF Cedar Junction and then was transferred to South Bay Correctional Facility. These were both in 2011. While there, he had received 3 D reports. One was for refusing to work on days off, one was refusing to stand for count, and the other one was a few days later, the exact same thing, refusing to stand for count. The Commonwealth also was able to reach out to our county, the Russell County Correctional Facility, for any more recent disciplinary reports while the defendant was there. It appears as though he received 9 D reports from March of 2014 through January of 2015 for various offenses while at the Russell County Correctional Facility. A common theme, Your Honor, seems to be being non-responsive to direction from any type of supervisor or person of authority while he's incarcerated. They stem from ignoring direction to something as small as a time to come out of a cell, a time to when to eat, a time to make a phone call, to something as extensive as the assault unprovoked on the guard, resulting in injuries as described. So it does appear that while incarcerated, the defendant posed a problem for security.
You continually espoused on the bench that it hurt you, and I understand that. But here I am with Mr. Russ facing heroin, and even this morning you did it again. And I'm very concerned that my client can get a fair sentence because, unfortunately, you keep saying that there's an epidemic. Mind you, this goes back to 2013, but there's an epidemic, and it's affecting you. I hope it won't affect you here. All Mr. Russ asks is a fair sentence. How can we discount? We don't know exactly what goes down in institutions, but we certainly know what goes down on our streets that involve people such as Mr. Russ, an African-American male. We have read about it continually, about what goes on. And it's not lost on me that not one officer who came in here was a person of color. And I'm certainly sure if you go back and look at the individual D reports, you'll find similarity. Then again, the ugly elephant in the room, racism creeps into every scenario.
The same indictment, possession intent to distribute Class B cocaine, and he did receive an incarcerated sentence for that. This is not the defendant's first drug conviction, and that is why the Commonwealth is departing from the guidelines. But it's
So
the
that's-
same drug, Class B cocaine.
It was simple possession. Again, are we going to deal with innuendo or we're going to deal with facts? The facts are he was found guilty of simple possession. And it wasn't cocaine, it was oxycodone.
If my memory's right, that's the case where the police were pursuing the vehicle and he was dumping the drugs out the car window, is that correct?
That was where the allegations.
All right. The crucial inference to be made in that case was whether the rest of the evidence linked Mr. Russ to the drugs found in the truck and the car. The search of his home on West Main Street revealed paraphernalia normally associated with the distribution of drugs. It is not unheard of that a sophisticated drug dealer will keep his stash someplace other than where he processes materials. The drug press that was recovered at West Main Street speaks volumes as to the scope of his operation. Other evidence, and in particular the items recovered both in the spare room at General Patton Drive and the apartment on West Main Street, supply the inference that the possession of those drugs was with the intent to distribute. The GPS pattern and, in particular, the drug press recovered at the apartment suggest the scope of this man's operation. This is not some sniveling addict who is dealing drugs to support his habit. This is an individual who is dealing drugs as his livelihood and business. As to the recent death of a young man who last week I hoped was on his path to recovery, I have spoken of it several times in this room. Not because it hurts me in some immediate way. No, I've lost many young people who have come through that back door over the last several years. Lost them to deaths from opiate addiction. There's nothing immediate about the young man's death of last week. And my reference to it in the last several days is not a reflection of any sorrow or hurt felt by me. And I hate to sound crass, but I've used that young man's death in the last week as an opportunity to hopefully impress the other young people that I have addressed in this courtroom as to the seriousness of the conduct they've been pursuing. My message has been very clear in the last several days. The fentanyl and the heroin on the streets of Cape Cod are killing our young people. When one sentences an individual, one sentences an individual not only for their offense, but for their character. Indeed, someone today has mentioned racism in this room. Well, I don't want to cheapen Dr. Martin Luther King's memory, but Dr. Martin Luther King said to all of us that what is the aspiration of minorities is to be judged not on their race, but on their character. That's what Dr. King said in a very memorable speech. And it is so true. One is to be judged on their character and on what they do, not on their race. So please, let's not enter something into this case that's not here. In essence, the case is proved and established by the Barnstable police through step-by-step circumstantial evidence. That's how they prove their case. And the brick-by-brick process that they went through to build their case is fortunately devoid of an individual identification or I saw somebody commit this type of analysis, which in folks who might be racially motivated could be used improperly. And that's not this case at all. It's brick by brick, item by item, circumstantial evidence leading to a finding. Fortunately, that type of evidence is less open to any suggestion of racism. I'm not new to the bench. I've been on the bench for 18 years. I prosecuted for 7. I actively defended on a daily basis folks charged with crime for 16, almost 17 years before coming to the bench. The D reports don't suggest that this gentleman has changed his character since 2009. Rather, they reinforced the character that led him to lash out at the corrections officer in 2009. Therefore, I think a top number is important in this case to encourage this man to change his ways and to give the institution the opportunity to respond if he does not. I am familiar with his record. I've studied it. I'm familiar with the offense. Taking all of that into consideration, I think the proper sentence is a bottom number of 4 years, a top number of 10 years. A very wide divergence for good reason. That would be on the cocaine indictment. On the heroin indictment, 5 years probation on and after. Is there any suggestion that this man has abused drugs himself?
What?
Has abused drugs himself?
Oh, all right.
Anthony Russ, hearken to the sentence of the court. You having been found guilty in the court having duly considered your offense as set forth in indictment 0701, charging you possession with the intent to distribute a Class A substance, and 0702, possession with the intent to distribute a Class B substance. On 2014-0702, possession with the intent to distribute a Class B substance. The court sentences you to the Massachusetts Correctional Institution at Cedar Junction for a term of not more than 10 years and not less than 4 years. Indictment 14-0701, possession with the intent to distribute a Class A substance. The court places you on probation 5 years from and after the sentence imposed in 0702, subject to the terms and conditions of the probation department with the no direct or indirect contact with any known felons. You're required to be monitored by a global positioning system. You pay a monthly GPS fee as established by the Office of the Commissioner of Probation. You're to abide by any exclusion or inclusion zones established by the Court of Probation Department in order to attend and successfully complete your management counseling and complete any recommended follow-up treatment deemed necessary, maintain full-time employment, job training, or employment search activities. On a probation matter, you're assessed a $60 monthly probation supervision fee and a $5 monthly victim services surcharge. You're hereby notified of your obligation to provide a sample of your DNA within 1 year of this date pursuant to General Laws, Chapter 22E, Sections 1 through 15. Failure to comply, you may be assessed a $1,000 fine, imprisonment in a house of correction for up to 6 months or both. Stand committed on this matter. With regards to the outstanding cases,
Well, I'm not done on this case, please.
Yes, sir.
Number one, I wish to deal with the credit that he's entitled to, which I believe is something in the area of 360 days, because the date of February 3rd, 2014, when he was revoked, and then he was then held for 60 days, then there was another 90 days attached to it because of the
Okay, let's start first. Let me start. Mr. Clerk, if you made a calculation.
I am not judge. We have to make
Mr.
that
Wilson.
calculation.
Let's start with a meeting with the clerk to see what calculation the clerk has. Then we'll go on, if you dispute it, to a hearing later today.
I've already got what they
I'm
wrote.
just telling you, first my clerk calculates days on the minimums. Then, if there's a dispute, we address it.
Well, then I can't,
That's how we're going to do it.
what?
That's how we're going to do it. You may meet with my clerk, you may calculate the days on the minimus, he will derive his calculation. If you dispute it, you will be given a hearing later today to discuss the matter.
Okay, still not done.
I didn't suggest you would.
I was gonna file a notice of appeal, but I can't file a notice of appeal or my withdrawal until I resolve the outstanding matter. Although I find it quite ironic.
Which outstanding, the days on the minimus?
Yes, Dave,
We'll address it before the day is over.
I find it quite ironical that Mr. Russ, when he gets out his probation, should stay away from any known felons. But somehow, we're not cognizant of what's the ratio of African-American males between 18 and 35 who had been incarcerated, put on parole, put on probation, etc. I guess I live in a different world. I also make a motion right now for the stay of the sentence pending appeal.
You are entitled to your opinions, Mr. Wilson. This court made its decision not based on the color of this man's skin, but on his character and his offense.
We cannot deal with, we cannot avoid reality, regardless of what is said, any more than the idea that inference on inference. I guess that's the way courts go. And perhaps it's good that I'm not going to do this anymore, because I don't see these inferences on inferences, because every time he supposedly went to General Patton, he went back to West Main Street, where you suggested the items were, where they could
Mr. Wilson,
produce things.
Mr. Wilson, you are entitled to your opinions, sir.
Okay?
And you may express them freely outside of this court. I've made my rulings, and that's how I see it. Thank you.
As to whether or not that would be a permissible reason to impose drug testing of the defendant while he's on probation for the 5-year period.
Can I be heard?
Only if you want to snatch defeat from the jaws of victory on that issue.
No, there's no drug testing. I don't want to be heard.
There's no drug testing.
Thank you.
There's no indication this man's abused drugs. He's a dealer, not a user. Mr. Russ, you have outstanding cases, as you're well aware. You're also well aware, I believe, that Mr. Wilson will be removed from the practice consider what you would like to do going forward as to counsel. You have an absolute right to be represented by an attorney. If you cannot afford an attorney, one will be appointed. If you want me to consider appointing an attorney, sir, on the remaining matters, my probation officer will see you in the lockup. You can complete proper form, and I'll review the form and then consider appointment, sir. Do you want me to have the probation officer? Thank you. That'll be done.